Okay. Thank you so much for everyone who's actually joining another session at Swakan through YouTube live stream, and also for the people who's going to actually watch after the live. Thank you so much for joining. And today we have with us Prashant Narang from Center for Civil Society to talk about importance and also connection between liberalism and rule of law. And Prashant is actually associate director of the research, who is also an advocate and also entrepreneur. He extensively worked with CCS on iJustice platform, which actually a legal initiative from Center for Civil Society to help the people with in terms of their legal assistance and also promoting their rights. And Prashant actually made a very, very strong and significant contribution in terms of CCS projects on easily doing a business and also street vendor rights, and also have creating a street vendors compliance index. And so his contribution towards these areas is very, very strong and very influential. And he was also teaching various law colleges across the India as a visiting faculty and empowering people on how you can actually utilize the law as a tool to actually empower more people and create an impact through legal systems. Thank you so much, Prashant, for joining, and I would like to give a floor.
Thank you for the generous introduction, Venkatesh. Um, so let me share my screen.
Sure.
I have a presentation on the rule of law. Just 1 minute, let me figure out. Uh, um, yeah, okay. Um, yes. So I hope, Venkatesh, please confirm, can you see my presentation?
Yes, I can see it.
Okay, great. Fine. So welcome everyone. I'm going to talk about the rule of law, and it's a bit technical. Law students and people who are into law, either practitioners or researchers, they of course know about the rule of law, but the rule of law is also an important component of the principles of classic liberalism. And it's not much talk about. People, of course, know what free markets are, people know about limited government, but the rule of law is slightly technical. And so a lot of people do not understand the rule of law very well. So let's take a look, and I hope I'm trying to explain it. I'll try to explain it to you in simple language. And if there are any questions, I'll take them in the end. Okay. Um, in 1880, a Hindi author called Bharatendu Harishchandra wrote a play called Andher Nagri. Andher Nagri in English means a city in darkness. And this is also a very famous Hindi proverb called Andher Nagri Chaupat Raja, Take Se Bhaji, Take Se Khaja. What it means in English is a city in darkness, ruled by a dolt, where vegetable costs a penny a pound and so does cashew, right? Now, this play was about, two thieves who were trying to break in, and the wall fell, and so one thief actually died, and the second thief filed a case before the king's court, accusing the house owner that the house owner wall was so weak that it fell, and so the house owner should be hanged till death for constructing a weak house or constructing a weak wall, right? So the house owner was summoned. And the house owner blamed the mason that he basically constructed a weaker wall and therefore he should be given punishment. Okay. The mason in turn blamed the cement mixer. The cement mixer blamed the potter. The potter blamed the passing mullah who was passing by, and he got into chatting with this person, and therefore he got so distracted that he made the pot with a with a wide mouth, and therefore too much water in the pot, and therefore the cement mixer added too much water in the cement. So the king decided that the mullah was responsible for distracting the potter, and therefore the mullah is to be hanged. Uh, but they found that the nose was too big and mullah's neck was too narrow, and therefore the king then ordered that find out a person in whose neck the nose would fit, right? So this was so whimsical that basically there are no rules, no principles. It's absolutely as per the whims and fancies of the king. So whatever the king will decide will become the law, right? And this is exactly what the rule of law is not supposed to be, right? This is how we differentiate between the rule of law and the rule of men. The rule of men is, for example, in the story that I just narrated, it was a rule of a man, right? It could also be plural, the rule of men. What matters is that it shouldn't be based on any whims and fancies. Of course, we also have parliament where there are men and women who decide the law that should rule our country. However, the same law applies to those people, right? So there is a system in place, there are procedures in place, there are certain principles in place. When we talk about the rule of law, it's not about a specific law, it's not about a law in particular. We're talking about what the law ought to be, right? It's a meta legal doctrine. It's not just about a particular law, it's a political ideal to achieve, right? And this is something that our constitution also talks about. So, for example, Article 14 of our constitution prevents against arbitrariness, right? Article 20 talks about that how we can't have retrospective criminal punishments, so on and so forth. So basically, if you were to try to sum up the rule of law in one sentence or in one phrase, I would say is the state should not be able to punish anyone except for breaking a pre-announced general rule, right? And what we mean by that. So, what are the characteristics of the rule of law? So, or how do we define law? So, in this context, then we define law as that the law must be prospective. It shouldn't be retrospective, right? So, you should be punished for your actions done under the impression, uh, that you're doing it in consonance, in accordance with the law. So you should be punished for something that was not an offense at the time of commitment of that action, right? Then the law should be known and certain. Law should be predictable. Law should be general. There must be judicial review. So, for example, if the law is, let's say, not prospective or it's not published or people don't know about it, right? Or it's not predictable or it's not general, then what is the remedy? Who decides that the law doesn't possess any of these characteristics? So there has to be some sort of review. And who does that review? The judiciary. So while the legislature makes the law and the executive enforces the law, the judiciary sees to it that the legislature is making laws that adhere to the rule of law doctrine. And the executive is not arbitrary in terms of its enforcement. Similarly, the next one is absence of discretion in interfering with private sphere of citizens. So there shouldn't be too much of discretion with the government or in the bureaucracy. Uh, okay. Okay. So let's take up equality before law first. You see the lady justice, she is blindfolded. And why is that? Um, she's blindfolded so that she can't discriminate between people who are, let's say, from different castes or different races or or different gender or different groups, right? And also, for example, in the Indian Constitution, Article 14 of the Indian Constitution, this principle of generality is enshrined as equality before law. So our Constitution says the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. The question is, why do we have generality principles? What if there are different laws for different groups? How does it matter? So let's take a look at some of the examples. So here is an example, and we can see whether it's a general law or a specific law. It reads, no person or establishment shall employ any man under the age of 25 years or any woman in any part of such premises in which liquor or intoxicating drug is consumed by the public. Okay. So you see the man, no man under the age of 25 years can't be employed, whereas woman, irrespective of her age, or woman of any age cannot be employed in a liquor serving premise. Now there is there's a disparity here because it treats men and women differently, right? It simply prohibits the employment of women in a liquor serving premise. So this is not a general law, it's a specific law. Here is another example. This law reads, dance performance of any kind or type in any eating house, permit room or beer bar is prohibited. 2. Nothing in Section 1 shall apply to the holding of a dance performance in a drama theatre, cinema theatre, auditorium, sports club, or gymkhana, where entry is restricted to its members only, or a 3-star or above hotel, or in any other establishment or class of establishment which the state government may, by special or general order, specify in this behalf. So you see what this law does. First, it creates a general prohibition. The dance performance of any kind or type in any eating house, permit room, or beer bar is prohibited. But Section 2 carves out an exception. Exception. So it says that this prohibition shall not be applicable to certain places, right? But it doesn't really lay down the reasons for this exception. And moreover, it also adds another proviso that the state government may, by any special or general order, exempt any other establishment or class of establishments. Right? So this is not a general law; it's a specific law. The examples that we see pertain to some sort of social policies, some sort of. But what about economic policies? So what about differential rate of taxation, right? You see, in India, for example, we have these categories. So we have GST. There are goods that there are commodities that are absolutely exempted from GST. Then there are certain commodities that attract 5% tax, 12% tax. Some commodities attract 18% tax, and some have 28% tax. So how does the government decide? And would it be general law or specific law that different commodities are treated differently? Right. So one thing I would like to mention that government may try to classify goods, right? So if it finds classification, a reasonable classification, it comes up with some categorization, it can treat different goods differently. However, the classification should be reasonable. But how do we decide that? How do we know that it is reasonable? So let's take this example. Let's say the government made tea tax free, right? So tea is made tax free, and government imposes 18% GST on coffee. What would you say? Is this specific law or is this general law? Or is this classification okay? Or is this classification questionable? Now, let me add another twist to this hypothetical. Let's say that the party in power has a stronghold in Hindi speaking states, which are also tea consuming states, the North Indian states, and it has weaker representation or weaker vote base in southern states that are mainly coffee drinking states, and southern states tea may not be so popular, right? Then do you think that there is discrimination? Would it be a specific law then? So this is why it's good to have uh, least number of categories, because it is very difficult to justify differential tax treatment. um, and if you think that here there was a very neat intersectionality of consumption pattern and and the group identity, we can take another example. Let's say Parle-G and diamonds. Which one do you think should have higher GST? So when I ask this question to my students, most of them answer the diamonds should have higher GST. Why? Because it's a luxury item. And Parle-G biscuits, being a poor man's biscuit. I mean, so many people, be it rich or poor, they all love to dip Parle-G biscuits in tea and have it, right? So it should either be tax free or have 5% tax. I came across this example first time, when I heard Shruti Rajgopalan talking about it, and she brought this disparity out. So the answer is that it is just the opposite. Uh, Parle-G has 18% tax, and diamonds actually have 0 to 0.5%, less than 1%, a quarter of a percent GST, right? So GST, this is just one example, but it's very, very difficult to rationalize and justify differential tax rates, right? So ideally, the government should have minimal number of categories and should have taxation as general as possible, and should not have specific categories as far as possible. Okay. Now, rule of law is more about the means and less about the end. Intentions, the objective of a law, the purpose of a law doesn't matter. It matters maybe for the government, for the legislature, or for the executive that decides policies or law. But for judiciary, what matters is the means. How is the law going to achieve that end? And whether that means is constitutionally permissible or not, right? Was that permissible under rule of law or not, right? So when we say that the categorization or classification may be permissible as far as the classification is based on some intelligible differentia, meaning that it is the classification is reasonable. So Indian standard of looking at classification, of scrutinizing classification, is twofold. One is that it has to be a reasonable classification. And second is there has to be a rational nexus. So let's take an example of, let's say, and environmental regulation that bans plastic, right? So let's say the law says that all street vendors shall not use plastic bags, right? Now let's look at this. What is it doing? It's classifying street vendors and other shopkeepers or mall owners or supermarkets into, it's basically dividing the based on who the user of plastic bag is, right? Who the provider of plastic bag is, whether it's supermarket, malls, shopkeepers, or street vendors. So only street vendors are banned. Does that help environment? So what is the nexus between the means and the end, right? The end is environment protection, and the means is banning the plastic bag based on the user, right? So, do we know that street vendors are the major uh, users, or the major consumers of plastic bags? So, if not, then this is not going to protect the environment, and then uh, this means would be a sham, would not serve the purpose. On the other hand, let's say if the government, for example, let's say the Delhi government has made a regulation based on thickness of plastic on the ground, that multi-use plastic bags are not as bad for the environment as thin plastic bags or single-use plastic bags, right? And so it decides to prohibit, ban single-use plastic bags. Now that has a rationale that you divided plastic bags into two categories: plastic bags that are way more hazardous than the other plastic bags, and those plastic bags are banned first. Right. So this could be there is a rational nexus between the mode of classification and the end to be achieved. Okay. Now let's see how other countries look at the classification or look at the standard of review for this purpose. Now they have evolved, especially the European countries have evolved something called as proportionality standard of review, and it's a four-pronged test. First is the legitimacy. Is the is the purpose legitimate or not? So sometimes even the purpose may be dubious. It may not be constitutionally permissible, or it may be something which may not be allowed either as per the constitution or as per some UN treaty. Right? Second is suitability. Is the purpose suitable to achieve the aim? Is it even in the direction that it would lead you towards the purpose or not? Third is the necessity. So is this means necessary to achieve the purpose? And what we mean here is that, or otherwise, can a lesser restrictive alternative take you towards the same objective? Can a lesser restrictive alternative fulfill the same objective, right? So for example, let's say population control. I'm not taking the example of population control because I believe population should be controlled, but this has been in popular discourse in India that population should be controlled. And the government comes up with different kinds of measures. And if you remember, post-emergency in India in late 1970s, the government suggested that the government actually went ahead with compulsory sterilization. Now the question is compulsory sterilization necessary for controlling population? One could argue that for that matter, genocide is the most efficient way of controlling population. But then is it necessary way of controlling population, or could you have a lesser onerous, right? So both these means, whether it's genocide or compulsory sterilization, both are highly restrictive. They curtail the fundamental rights, the individual rights of individuals to great extent. Right? So can we think of lesser restrictive alternative to do that? Right? And the fourth is balancing. So balancing is what are the competing interests. Right? So for example, if you want to promulgate an environmental restriction, but if it has adverse effects on livelihood, then you have to sort of do a cost benefit analysis to see what is the cost of that environmental protection, right? So this is the proportionality standard of review. Now we come to administrative discretion, right? And what do we mean by discretion? Here is an example. So here is a law which says the deputy commissioner may fix a period to be an agricultural season with respect to such villages as may be specified therein. Second, the deputy commissioner may prohibit the manufacture of BDs during the agriculture season. Number three, no person residing in a village shall during the agriculture season engage himself in the manufacture of BDs, and no manufacturer shall during the said season employ any person for the manufacture of BDs. So there are three things. One is there is absolute discretion with deputy commissioner as to in terms of fixing the period for agriculture season. Right? There is absolutely no guidance given here. So if the deputy commissioner says that okay, June and July are agriculture season, then that will be the agricultural season. Or if it says November and December are agricultural season, that may be agricultural season, right? There is absolutely no guidance given here whether agricultural season would be with respect to the rainfall, or with respect to monsoon, or with respect to any other objective criteria or benchmark, right? There is absolutely no. So it's totally up to the deputy commissioner to decide what an agricultural season is. And during that season, he can prohibit. So basically, he has the discretion to prohibit the manufacture of BDs during the time that he wants to prohibit. And third is during that time when he prohibits the manufacture of BDs, then the factory cannot engage the labor, and the labor can't be employed in those factories, right? So deputy commissioner, by his discretion, can bring BD manufacturing to a halt, right? And he can decide time, and there is no minimum or maximum duration of that time period also indicated, right? So huge discretion. Now this discretion is antithetical to rule of law. Why? Because we see that rule of law has to be predictable. It has to be, there has to be an element of certainty. But where is the certainty here? Where is the predictability here? And where is the objectivity here? And where is the generality here? Because generality would mean that you have sound classification based on some criteria. But here, deputy commissioner can decide the period, can decide the villages. He can also specify the villages where to, to those villages this would be applicable, right? And there is absolutely no criteria given for that sort of classification. So there is absolute scope for arbitrariness here, and therefore this is problematic for the rule of law. Okay. Uh, this is a new movie released last month, Gulabo Sitabo, and this is about rent control laws. So you see, this is the here is there's one landlord and there is tenant, and the tenant has to pay only 30 rupees per month, and in the city of Lucknow. The question is that a fair rent? And who decides what is a fair rent? And how does that rent controller decide what is a fair rent? Right? The problem is, if you have seen the movie, that the landlord cannot evict the tenant, the tenant can also not enjoy the property, and they are perpetually in the state of conflict, right? So landlord keeps looking for ways to harass the tenant, and the tenant never pays the rent on time, and of course the rent is so low, it's only 30 rupees, and that also he never pays on time, right? So both are always in conflict, and if you've seen the movie, you also can appreciate that how both are losers in the end, right? They both end up losing the property. Like the rent control laws, all other economic laws, be it the land acquisition law or the economic control law, the price control law, or the quantitative limit or licensing laws, these all laws are are problematic. The reason, so for example, rent control is also a price control law. The problem is, how do you decide price? And as soon as the government tries to come up with some formula for price, the formula uh, has to be some, it has to be arbitrary. The problem is, you cannot come up with a fair formula, because what the price that the market determines has to be the fair price, because market price is determined by the law of demand and supply. So in the case of rent control law, they try and peg it to some time period or other properties, and it becomes very arbitrary. It doesn't really signal the price fairly, truly, correctly. Similarly, in case of land acquisition law, there are many such uh, issues in land acquisition. So, for example, the government can only acquire land because it is a coercive measure if there is a public purpose, and the definition of public purpose becomes a question. How do you decide public purpose? What is a public purpose, right? Then after the land is acquired, what sort of compensation is given? What is the formula for compensation? How do you decide that compensation? And that becomes a very difficult question. Similarly, in case of quantitative limits, right? So for example, Delhi government came up with a limit for cycle rickshaw pullers, that Delhi will have only 99,000 permits for pulling cycle rickshaws, right? But how do you come up with that formula that 99,000 is the right number for cycle rickshaws, right? I mean, there are, for so many other sectors, there is no such number. So the government doesn't decide the number of, for example, let's say lawyers. The government doesn't decide the number of shops. The government doesn't decide the number of barbers, and so on and so forth. So how does it decide the number of, let's say, cycle rickshaw pullers, right? It, by the way, also doesn't decide the number of cars in Delhi or buses in Delhi, right? So then these examples, they don't treat other similarly situated parties, in the same fashion. So of course, it's a special treatment. It's not a general law, but also that it becomes very arbitrary as to why a particular price or why a particular limit, the numeral limit. It becomes very, very difficult. Right. Similarly, in case of public corporations, they have preferential treatment. So, for example, if you see most states in India, the education department that they have runs public schools, but as well as it manages, it regulates private schools. So while it performs a managing function or provisioning function, it also performs the regulatory function, right? So it's a cricket match where the umpire is from one of the teams playing, right? So there is conflict of interest. Department of Education in any state, there's a conflict of interest that it is regulating its own schools and it's also regulating its competitors, right? So these are especially in contravention of the principles of rule of law. Now let's look at socialism. Socialism needs planning. Planning requires information and management, and central planning requires discretion. Why? Because you have to allocate resources. For allocation of resources, you want to control price, you want to have discretion, and then you would keep coming up with orders, you would keep passing orders, and to pass orders every now and then in order to control the market you would need huge discretion. So for example, in 50s, for example, the cotton control orders. So at some point bureaucracy had to pass, or there were more than 500 orders in a year passed, and it was very difficult for the traders to keep up to the number of laws. Similarly, if you see during COVID time, there have been thousands of notifications passed under Disaster Management Act, right? And it is so difficult to keep up with the notification. Similarly, if you remember 3-4 years ago when we had a demonetization, in 4 months' time, the government passed hundreds of orders to keep pace with the with the emergency time that it had created the crisis it had created. And otherwise, you see in normal times, so for example, when there is some sort of demand and supply of currency, there is usually never such a requirement. But when the government tries to control, tries to manage instead of govern, then it has to pass thousands and hundreds of orders to keep pace with its controls, right? The discretion is inimical to liberties. It is, antidote to, it is antithetical to the rule of law. And when it gives a lot of powers to bureaucracy, and that power corrupts it, right? So where you have socialism, you cannot have the rule of law. They both don't go along well with each other. Okay. Now, if you remember, we also talked about judicial review as a component of the rule of law. Now, if you look at Indian Constitution has a provision called Article 31B, which basically creates a ninth schedule in the Indian Constitution. And ninth schedule is a black hole, right? Black hole in the sense that that law can't be judicially reviewed. Now, of course, with some judgments, precedents, the judiciary does look into those laws. However, those laws can't be scrutinized for their compliance with fundamental rights or with the Constitution, but judicially now reviews them against the basic structure, which is some sort of a higher norm than the Constitution. It's a fictitious norm, but it is the higher norm than the Constitution. It's a fluid norm. So judiciary decides what basic structure is, but it's the core principles taken from the Constitution that are non-negotiable. Right? So when this ninth schedule was carved out in the Constitution by way of the First Amendment in 1951, our Prime Minister said, well, this is the first and last time, and it is going to be rarely used. It will never be used again, right? But now we have 284 laws in the ninth schedule, right? And that shows the kind of violation that our Constitution goes through. Okay. Rule of law also demands that the adjudicatory body has to be impartial. especially in cases where the government is involved, where in cases of violation of fundamental rights, we petition the court, we file writ petitions before the court, right? And the court has to safeguard our fundamental rights from the state, from the government abuse or government uh, powers, right? So the courts have to be independent. And there is a fallacy, there is a fallacious impression in India that the Indian courts are highly independent and they are free from government influence, right? Why? It is true in the sense that the parliament, of course, there is impeachment, but before impeachment, lesser than impeachment, there is nothing that the government can do or the legislator can do to a judge if the judge gives judgment that the parliament or the government doesn't like, right? However, post-retirement appointments are decided by the central government, right? And there is empirical evidence by scholars that shows that Supreme Court judges pander, and though they give judgments uh, to the liking of the central government, to the party in power in the central government, so that they get better post-retirement opportunities, they get better post-retirement appointments, right? Then the other system, which is highly political, is appointment of government councils as judges in the High Court. So first of all, because government is one of the, not one of the, but government is the, the most litigant, the biggest litigant before the courts. It has highest number of cases before the courts, and so of course all government authorities appoint their own councils, empanel councils, and this process of empanelment or appointment of government councils is political. There is no objective criteria, and it is highly political. So the ruling party appoints its cadre as the government councils usually, and those same councils then eventually, some of them eventually go on to become judges in the high courts. Of course, they get a lot of exposure and their face value increases in the courtroom, so on and so forth. But of course, in the first place, because they had good contacts with the government, they managed to get those posts. And then from there, if the ruling party is still in the power, they go on to become the judges, get elevated as judges in the high courts. And from high courts, then they go to the Supreme Court, right? Then the other thing is that in our judicial system, hearings are not recorded. Even the plaints filed by the parties, the plaint or the responses filed by the parties, the briefing filed by the parties is also not recorded, right? And that adversely affects the quality of the judgment. So the quality of judgment is really poor in our system. Sometimes the judges do not even respond to all the contentions. And what happens in the courtroom, that is highly opaque, because of course there are people there, there are lawyers there, but since media doesn't have, and the court also has the weapon, the tool of contempt, therefore it tightly regulates its bastion. It doesn't allow harsh criticism of either judges or of the judgments, right? So it's not very open to public scrutiny. It's not very open to public criticism. Of course, scholars criticize the judgments, but that's still limited to only lawyers and law students. And the media, although can cover judgments, can get access to courtrooms. However, it is not permitted for them to also indulge in harsh criticism, right? It can't pass comments on judges and so on and so forth. So the courts, I mean, these are some of the institutional loopholes that affect the impartiality of our court system. Okay. Now there is something called as the Rule of Law Index, which is put forward by the World Justice Project. It has some parameters, and these are the parameters constrained on government powers absence of corruption, open government, fundamental rights, order and security, regulatory enforcement, civil justice, and criminal justice. And it measures these parameters in all countries and comes up with the rankings. So let's take a look at the Indian ranking. Right, Indian rank is still 60, it's now 69th. It has slipped to 69. This is old ranking of 2017-18. Um, so somewhere it is in the middle, but the indicators where India performs really bad, uh, and that's, you see, it's civil justice, where India ranks 97 out of 113 countries, right? And on order and security, it ranks 98 out of 113 countries. It does fairly okay on open government and on constraints of government powers. Um, on regulatory enforcement and criminal justice, it's somewhere there in the middle. But on order and security and civil justice, it does really poorly. And we can see the sub parameters within each parameter. So, for example, if you see um, civil justice, civil justice, and look at point number 7.5, right? On 7.5, which is no unreasonable delay, India scores 0.16, right? It's abysmally low score. And 0.16, it's really, really bad. And if you look at, uh, the green line and the orange line, these indicate, I think, the global average and the regional average. India is way below those averages, right? So it's really bad. Then also on 7.6, which is effective enforcement, India does poorly. On non-discrimination, also it does poorly. Similarly, in criminal justice, also there is non-discrimination, which is 8.4. It does poorly, right? Effective investigation and effective correctional system, it does really poorly, right? Okay. Yes. So this was my presentation. I'm open to questions. I'm done in 45 minutes. So we do have 15 minutes for questions and answers.
Okay, thank you so much, Prashant. It is very interesting presentation and also talk, especially someone like me who's actually have no understanding and legal systems and engineering graduate. And I was just wondering, with the case with most of the Indian constitution and also legal system, it was different. I mean, many people see that there is a gap between common person and also understandability of Indian legal system or a constitution. Do you think there is a gap, and if there is a gap, how we can actually fill it? How we can actually simplify these laws understandable to the common?
Sorry, can you please repeat your question, Venkatesh?
So there is a gap between understandability of the constitution or legal systems of India and the common people, and regular people, even though who is actually
Okay.
studied well,
Yeah.
but I mean, like they didn't study the law or
Right.
any other legal aspect. So how can
Sure.
we actually, if there is a gap, how can we actually bridge that gap?
Yeah. Yeah. You're right. So our constitution is too long. It's too big. The constitution should be shorter and simpler. It should be easy to understand. There's a saying called "too many laws in a country would mean too little justice," and that's so true for India, because we have too many laws and too little justice. Truly. Uh, so first of all, I think we should repeal all useless laws that are redundant, that are archaic, or that just impinge on civil liberties of citizens. So limit our laws and have simply written laws, laws that are written in simple and plain English, not in legalese, because it becomes very difficult for citizens to understand those laws. Um, and the constitution, of course, doesn't need to be so long. I think that would bridge the gap to some extent. Yeah.
Okay. Okay. Thank you so much. And so, is there any correlation between standard of living or quality of living and the rule of law? So, how it actually affects the standard of living in general or any specific case?
Um, I think so. First of all, rule of law itself has different conceptions. I believe in the classical liberal conception of rule of law, or Hayekian conception of rule of law, that talks about presumption of liberty, that talks about property rights, in addition to the procedural aspects of rule of law. And of course, so if you have presumption of liberty and property rights and procedural fairness, then definitely it would show on the quality of living and the per capita GDP and all other economic indicators, I believe. Um, yeah, but other people will have counter arguments, because their conception is different, and they might also question it on empirical evidence. Although I believe, for example, I think it was Heritage or Fraser that has probably shown a correlation between rule of law and economic indicators. Yeah, I'm not too sure about causation, although intuitively I do see and I believe that a society which has a rule of law would tend to prosper.
Okay. Thank you so much, Prashant. And my next question is actually about you were actually telling about the executive branch, the government executive branch can actually um, able to actually influence the judicial system of India. So, do you think we needed to improve our separation of powers in terms of legislative, executive, and judiciary bodies?
Absolutely, I couldn't agree more. We desperately need to improve the separation of powers in India. Indian Constitution does talk about separation of powers in the directive principles, but it's not been taken so seriously, right?
Yeah.
The other thing is administrative law is also not being taken so seriously. We are too driven by the purposes of law. We're too driven by directive principles, and we don't pay attention to the means, and we pay rather more attention to the end of the law. And as classical liberals believe that uh, good intentions are problematic. They say no road to hell is paved with good intentions. So yeah.
Unfortunately, you talk about the means of the in how we actually achieve the law very very specifically in your presentation. And so in India, I mean, like most of the times we're seeing a lot of extrajudicial killings, especially a recent Hyderabad gang rape case. We said there might be actually criminals or not. It should actually decided by a judge uh, through a due diligence and also clear investigation through that one. So do you think our people faith in the judicial system is actually loosen up, their confidence in the legal system is actually dropping down?
It is dropping down, and the reason is because the system has failed to deliver. The civil justice has failed to deliver. The criminal justice has also failed to deliver, and it takes years and years. And this is why people now want to take justice in their own hands and believe in immediate justice, instant justice, right? And therefore, we do see a phenomena of mob justice in India, and the reason is precisely because the government has failed to deliver it, right? So people no longer believe in the system, in the procedure, and they want to see the outcomes. And this is why they take the law into their own hands.
Why do you think a clear investigation is necessary? I mean, like to actually decide what kind of punishment we should give to the particular convict.
Uh, I mean, that's the, so how would you know that a person has done a crime, right? So
Yeah.
you need evidence, and for evidence, you need investigation.
Hmm.
Who does that investigation? There may be, arguments. There may be a discussion on who would do that investigation. So for example, you might have private parties to do investigation. So you can
Hmm.
have private detectives, you can have state investigation agency. Now
Hmm.
there are arguments, for example, that say that these functions of the police, so for example filing FIR, investigation and prosecution, these should be separated,
Yeah.
right? But you have to have investigation, clear investigation. Who does that? There can be different ways to think about that.
Okay, okay, okay. So we've seen that the faith in judicial institutions actually dropping down. How do you think we can actually restore it? What kind of reforms? You don't need to go to very specifically, but in general, what is the most important things that how we can actually restore the
Sure.
reform the judicial system?
Yeah, yeah. I think for civil justice, definitely we should have robust systems of arbitration, and we should also free arbitration from former judges. So what happens in, for example, the High Court is High Court often refers cases for arbitration to their former judges, right? But instead, I think the arbitration system should encourage other people or institution forms of arbitration and should make it cheaper. Right now, arbitration is also so expensive that most people are not able to afford arbitration, right? And by default, the first step should be to send every case for mediation, and then after mediation to private arbitration, and free court system from civil justice as much as possible, right? So by default, it has to go to, let's say, for arbitration, private arbitration, and only where it is imminent, or we can, I mean, the court can evolve its criteria for what sort of cases should be marked for court system adjudication. Criminal justice, I can see the point that why state court should be in criminal justice. However, uh, a lot of laws, lot of offenses can be dejudicialized. So, for example, recently the government dejudicialized check bounce. Why did check bounce need to be a criminal offense to begin with? Most countries treat check bounce as a civil issue, a civil breach of contract, right? Not a criminal breach of contract.
Yes.
And this is why our system is clogged with so many cases, pendencies. So we can remove many of these cases. We can dejudicialize those offenses. We can remove those offenses and focus on the most heinous crimes, most grievous crimes, rather than focusing on petty issues. Similarly, for corporate, under the company law, there were many violations that were treated as crimes, right? And there was a demand from the corporate world to decriminalize those violations. So, and in many other laws, this is the case. So that should be done away with.
Okay. Thank you so much, Prashant. And one other question from audience is so when it comes to the legal judgments, and sometimes there is a difference of opinion between the judges. So how judges actually interpret the law in a high court or a local court or Supreme Court is sometimes actually differs with each other. So do you think law is actually subjective in India, or should it be more objective oriented?
Is the law subjective or law is objective?
Objective, yeah.
Oh, that's so law is subjective, but there are some objective indicators also within the law. However, the quality of our judgments indicate that the quality of judgment at times is so poor that it doesn't even connect to even to those broad indicators, to those broad benchmarks. Of course, there is element of subjectivity, but in terms of quality and objectivity, they could be relatively much more objective. Yeah.
Okay, thank you so much. And one more question. It's more about so what kind of the the correlation between rule of law and limited government, because um, the question says something like this. For the people who is actually politicians or someone who is actually connected with the power, like bureaucrats, can easily manipulate enforcement of the law, like a police systems, and
Yes.
then actually poor people. So, do you think there is a strong connection between limited government and the rule of law? So, limited government able to actually improve or incentivize better rule of law in terms of accessing for the common people?
Yeah, yeah. So, how classic liberalism conceives limited government and rule of law, in that system both would go hand in hand.
Yes.
Why? Because the kind of examples that I gave in the end, you see example of, let's say, land acquisition, rent control, public corporations, economic laws, licensing laws, quantitative licensing, quantitative limits, right? Price controls. So these laws don't go well with rule of law, right? Because these are arbitrary laws, and these laws are also not in accordance with the limited government norm. So you don't need these laws both ways.
Yeah. Yeah. So I will actually go with some of the work you guys actually do at Center for Civil Society, and could you tell us about so you extensionally actually work with street vendors and also their rights, and you also recently setting up a new initiative called Law for Liberty. Could you tell us about what kind of work actually you do, how it actually connected with the people, and improving the rule of law?
Sure. So in context of street vendors, um, because street vendors were harassed, still continue to be harassed by police and municipal officials. So our purpose has been to ensure that they are able to carry on with their livelihoods without any harassment. So now there is a parliament made, there's a federal law in place passed in 2014 that talks about that how they need to be protected. There should be a survey and so on and so forth. So we did file a litigation to ensure that the law is enforced in state of Rajasthan. Eventually, that happened, but we thought that it's difficult to then keep a check state by state and see which states have enforced it, which states have not enforced it, and then it would be very long time to ensure that. So eventually, we came up with the idea of an index, something similar to ease of doing business index. This index is a Street Vendor Act compliance index, and we bring out a progress report every year, wherein we measure and track every state of India, how to what extent the state has complied with the provisions of the Street Vendor Act, and it's a comparative index. So there is a nudge to the states that they should improve their performance on the index and try and comply with the act. So that has been somewhat successful because many states have improved their performance on the index. Having said that, but we also do a little bit of litigation for the vendors. So last year, for example, here some vendors in Delhi were challaned, and the magistrate imposed huge penalties, much more than what was written in the law. And we took up their case, represented them before the municipal magistrate, and then went on to the session court. And then the magistrate had to acquit those street vendors, right? So they won. So this is some of the work that we do.
That's really good. What you guys actually doing through these livelihood initiatives are actually having a tremendous impact. And my family itself was actually, my mother was actually a street vendor for many years until my brother and I got a job. And
Oh,
the impact that has on the street vendors, it's really, really very high. And I could actually really connect the work you guys are doing. Could you also tell about your upcoming project, Liars for Liberty. You recently won an Atlas Network Award for that initiative. And could you explain what are you guys going to do with that project? Uh,
Yeah, so the case that I just told you about, where we represented the street vendors and we challenged the excessive penalties. After 4 months, this street vendor was challaned again, and he went to the same. He went to the municipal magistrate. This was a different municipal magistrate, but he also tried to impose challan, and he refused to pay. And the magistrate threatened him. He said, "I will send you to a higher court." And I will send you to Patiala House Court. He said, but this case doesn't fall in the jurisdiction of Patiala House Court, it falls in Saket District Court. So the vendor, what I mean to say is the vendor was so well informed about his rights that he didn't need us to be represented before the court, and he contested the court and the judge had to let him go. So in our Lawyers for Liberty project, this is our objective, that we create some sort of videos or audio visuals for the vendors across the country, and we empower them to the extent that they don't need lawyers, at least for most cases, and they should
yeah.
be able to represent themselves, should be able to know their understand their rights, how to carry on, for example, their meetings in town ending committees, rights complaints, file memos and representations to the government, and so on and so forth. Sorry, 1 minute. Uh, so this is our objective, that they're more legally informed and are able to they're legally empowered and they're able to do these some of these things on their own, so it becomes sustainable. We can't be there everywhere, and so they would be able to defend themselves and protect themselves. Yeah.
Thank you so much, Prashant. That's actually a very, very wonderful initiative to giving a tools that where they can actually defend themselves in generalized cases most of the time. And one last question. So CCS is one of the leading think tank, and you involved very a lot with CCS, and so most of our audience is actually people who are actually political activists who runs NGOs and social enterprises, and some of them actually tech graduates. So there has been a rising interest in terms of public policy and how they can actually involve in the public policy, how they can actually impact through the policy making and lobbying. So, what kind of opportunities you guys can actually provide uh, for the alumni of Swatantrata, or people who is actually joining Swakan,
Yeah.
especially especially law graduates, as you are actually doing do that.
So we do have internship opportunities, particularly for law graduates. We take a lot of law interns with us to work on the research and to work on the street vendor project. So people who are interested can write to us at internship@ccs.in. We would be happy to consider their applications for internships.
Thank you so much, Prashant. I really had a very, very interesting conversation with you, and your presentation was very, very interesting and also easy to understand. The concepts you actually tell, the way you presented, and thank you so much for joining. Thank you so much for giving your time, support, all the time you guys at the CCS actually provide for an organization like ours. Thank you so much, and we would like to work with you. Any common ground we can find and common objective we can actually promote.
Thank you, Venkatesh.